Okay, a very good afternoon to all of you, and I welcome you all to today's study group meeting. We have two sessions planned for today. The first session is on wills, nominations, and related topics. So to discuss on the same, we have with us a very senior faculty, CA Rajeev Shah. He will be guiding us on the intricacies of the wills and nomination aspects. To take the formal introduction of today's speaker, I would like to invite our core group member, Atul Mathuria ji.
Good afternoon. It's my pleasure to introduce CA Rajeev Shah. He is a practicing chartered accountant and owns a firm of Biyani and Shah in Mumbai. He started off his career in 1982 immediately after clearing his final CA. His main area of interest are direct tax, international tax, payment banking, and finance and allied laws. Rajeev is actively associated with WRC and also been member of various committees as Research Publication Committee, Research Committee, Direct Tax Committee, Banking, Insurance and Pension and Professional Development Committee, Student Committee, and presently MSME and Startup Committee. Since the last several years, he is a member of WRC Referencer Manual Publication Group and plays an instrumental role in publishing the content of their yearly manual referencer. He is also empaneled with ICI as peer review, reviewer and peer review board, and is a technical reviewer with financial reporting review board. With this brief introduction, I request you to please welcome.
Momento. Yeah.
As a mark of our love and affection, I request a senior member to memento.
Yeah. Thank you.
Pintan.
Thank you.
Thank you. आप बैठिए मैं आपको सेट कर Request everybody to please keep the phones on silent mode during the meeting.
Good afternoon, friends.
वेट कर दे ऊपर वेट वन के बाजू में जो ऊपर वेट वो कर दे वो नहीं इसके बाजू वाला अरे वो क्या ना बस वो कर दे
पूरा नहीं आएगा नहीं फर्स्ट पेज नहीं मैं तो यहाँ से चलेगा
ऐसा इसको थोड़ा सा बड़ा करना हो
नहीं आप करके नहीं फिर पूरा नहीं आएगा
आपको पूरा ही चाहिए ठीक है
इधर बराबर इज ओके फॉर यू Now today we are going to discuss about the will, succession, and the nomination. The first, what is the will? Why we make the will? We all work hard, we all earn money. Then what we want? It should pass on to our generation peacefully. That's our aim. But many times, if we don't plan by our will, and if we go, then what happens? अपना फैमिली वाले में डिस्प्यूट चालू हो जाता है और वो क्या अपने को बोलेगा ये तो गया लेकिन हमको तकलीफ में डाल के गया so that is the important why we should plan out the most important thing is if you remember Dhirubhai Ambani forgot to make a will And you all know what has happened between Mukesh and Anil. It is just because their mother were instrumental and it has been sorted out. So now after that, let us discuss what is will. Indian Succession Act has defined the will. One second. Will means legal declaration of a testator with respect to his property, which he desires to be carried into effect after his death. So as the word suggests, what is the important portion of this definition? It has to be a disposal of the property. It's not only your wish. You can't say, I wish like this or that. You have to dispose of the property. And it has to be declaration that it is to after my death. That has to be specified that it has to be after my death. This is the property which I am disposing of. And it is revocable during the lifetime. One can make any number of will and change every time. The last will prevail. And it has to be a legal declaration, means in accordance with the personal law. In case of Hindu, Hindu, Muslim, Muslim, and all personal law will apply. Now coming to the thing, what we have discussed is what is will. Now the next question comes who? Who can make the will? So any person of sound mind and measure, he can make the will. Now, what is the measure? In normal course, at the age of 18, it is a normal, he becomes the measure, any person. But in case, if court has appointed a guardian for a minor, then he attains the majority at the age of 21. So till that he cannot make the will. Now, another point, deaf, dumb, and blind can also make a will. If they are major and they are of sound mind, they can make the will. Third, even insane person can make a will during his lucid interval. But there we have to take a proper care to prove that when he has made the will, he was sane. And that is why doctors and every certificate, the time should be noted down, when, what time, who were the present, everything, that all care has to be taken for that case. Now the question comes, when to make will? Normally everyone feels, अभी क्या जरूरत है? Retirement हो गया, बाद में देखेंगे. But today's life is very stressful life. Number one, and number one, there is no certainty about the life. So whenever, at least when you are married and you have a family and have a property, then you must think of making a will. And after making will, it is not that it becomes the final. If you want to change, you can change it. Now, what is the basic requirement of making a will? What is the essential thing? Is the signature of the person. Before that, I will give the certain terms. The person who makes the will is known as a testator. And in case of a female, it has to be testatrix, not a testator. Now, when you make a will, you have to appoint someone executor. Because after death, someone has to execute the will, whatever you have disposed of the property. So whoever is going to act for that is known as executor. The third one is the witness. It is a must essential condition that there has to be a witness, two witness. And fourth is the legati. Legati means the person to whom you have given the property. And the legal term, it is known as the bequest. You have bequeated the property to so and so. So property is known as bequest, person to whom given is known as legatee. So these are the basic terms. Now, two things is more important. The signature of the testator who has made the will at the last and at the proper place where it appears that he is signing as the making of the will, not a normal signature. That has to be very important part. And two witness, that is a must. And each witness will be saying the person who has signed, testator, is in our presence. And we know, but the witness is not supposed to know the content of the will. He is just witness that person who is signing, testator, he is signing that
सिग्नेचर का विटनेस
signature का witness.
बाकी नहीं पढ़ाने का
नहीं, आपको इच्छा है तो पढ़ाओ.
सूची सामने रखें जरूरत नहीं है पढ़ाने की.
He did not know the content.
should not know this
There it is the. So because of that thing, who can be the witness? You have to prefer a young age. क्योंकि अपने उम्र का और अपने से ऊपर वाले का रखा. And in case of the dispute arises after our death, they may or they may not be available. And when dispute comes, the witness plays a major role that he has signed in my presence. I was, and he makes all the statement that justifies that the will is proper. So testator, I mean witness, and later on comes the executor, both should be the young one. Because many times the executors may not survive you. So then becomes again difficult. Even I will give you the example when the executors were appointed and later on for some reason or other, he has resigned. He has resigned, not refused. He thought that there is a dispute among the family now. So why should I be involved?
उन्होंने मना कर दिया
And this was the practical case. What has happened? Witness was a chartered accountant. He was his.
In that case, can we write that a year by upon Victor A executor in his absence, Victor B.
Yes.
That
That-
can be done.
We can appoint the alternate executor also.
If he denies to accept the role of an executor, then Mr. X, instead of.
Yeah.
We should
We-
draft it accordingly.
We have to appoint two or more.
Can we appoint two jointly?
Yes, but.
Joint is also possible, or alternate is also possible.
Joint taxation is a problem to form an AOP.
No.
Two executors will form an AOP.
No, joint, it's the just the,
Where is the question?
they are not the owner, they are the, it will be, see, up to the death, see,
How can it be?
up to the death, he will be assessed by legal representative.
Correct,
After the death,
right,
executor will obtain a new pen as an estate of the so and so,
right.
and it will be assessed as a separate entity.
Okay, even if there are multiple executors, joint.
Joint, because of the estate, the managers can be different. They are not the owner.
Okay.
Even I have skipped the taxation part also here, because again it will take a separate session for that. So in that case, he has resigned. In that case, what has happened, the mother was expired. There were one son, other son was expired before that, and his wife was in USA. So he thought, इतना टाइम वो इंडिया में रह के मेरे साथ फाइट करेगी. He captured everything. And practically they were known to me. They came to me, and he was not replying. List of the property, forget whether he has applied for the probate or no probate. Later on, she met lot of lawyers. Some said you file criminal case against them. It is possible. Some say file caveat, but how can you file the caveat when there is no probate applied? After a lot of relatives pressure, he said, yes, I applied for that. And ultimately, the cost which was quoted by the lawyer, 3 to 5 lakhs rupees was coming. And she was not having that much money also. Because the person was fighting with that money. So he was affording the best of the lawyer. Even I suggested you make a compromise, whatever he gives, take it away. But still it is going on. And in fact, he has spent money out of that also. Anyway, that's all. So now basic requirement, the most is signature of testator, the place where is to be signed, 2 witnesses. He will be justifying that he has signed in my presence. As we said, it will be a young age, preferably 1 witness should be your family doctor. Because you have to justify while at the time of this, he was not even intoxicated. Not only sound mind, but not intoxicated. There was no coercion. There was no force of one else. So doctor is that thing. Even later it will come. Witness will be the doctor, but it is suggested you go and register the will, though it is not mandatory. And at the time of registration, also you take a certificate from the doctor. Then register it. Now, will can be on plain paper. Simple writing is also provided. There is no complication as per the law. It is not required to be registered. It is not required to notarize. It has made so simple, but because of that, maximum problem comes. So you have to take care of drafting the will and see that the least dispute arises. And if dispute arises, there are high chances that will sustain. So one condition is that you get it registered. The register process is very simple. Yes.
I have seen wills in which it is written that if any beneficiary in this will disputes this will, his rights in the will go away.
I covered that point.
Okay.
Yeah. So, but how long it will be valid? That clause I have discussed. That if anyone, whether he has been given property or not given, if somebody dispute, he will not get anything out of it. But when it will apply, will is sustained. If it is proved, it has been obtained by fraud or under intoxication, then the will itself will get nullified. So what will happen? It will go intestate succession. So if you have taken enough care and will just justify that it is the valid will, the dispute is different. In that case, that clause is very, very important. So what happened? Normal family will never try to dispute. Will is correct, but everyone wants to fight. कि मेरे को कम मिला, इनको ज़्यादा मिला. That's always the issue. So they go for the litigation. Or some litigation, you know, it runs for the years and years. So people will, okay, chalo जाने दो. I will tell you, मैं actually last के लिए रखा था. While making all this will, what we need the peace, right? I think majority may be knowing the letter written by G.D. Birla, Ghanshyam Das Birla, to his son, V.K. Birla. वैसे मालूम है आपको? उसने बहुत, it's the best of the letter written to the son. उसमें उसने वही लिखा था. अगर आपका बेटा आपकी प्रॉपर्टी अय्यासी में डालने वाला है, उसको कभी पैसा मत दो। ये समाज का पैसा है, समाज के लिए खर्चा कर डालो। और उसका सब्सटेंस क्या था? अगर कपूत है तो क्यों देना, अगर सपूत है तो देने की जरूरत है, वो अपना साम्राज्य खड़ा करेगा। तो ये समाज का पैसा है, आपको समाज के करना चाहिए। अगर ये प्रिंसिपल दिमाग में रखना, और सबको कोई भी क्लाइंट आता है तो उसको पहले ये ज्ञान देना चाहिए कि आप सोच के सोचो, क्योंकि वी ऑल गेट कैरिड अवे बाय द इमोशन। ये उसी इन द महाभारत। So now, so registration is over. As I said, you take the certificate from the doctor, and registration, as you are aware, after making will, within 4 months, you can register. And many times, if we are not able to go to the registrar office, there is a provision the registrar can come to your office, your house, and we can do it.
So what is the stamp duty for that?
No stamp duty.
No stamp.
Absolutely no stamp duty. And even after your death, when property passes to the legal heirs or succession to whom you have given, no stamp duty for transfer, no capital gain, no taxation, no effect.
बिल का वही फायदा है।
हाँ.
खाली वो जो कोर्ट का एक कुछ लगता है वही
Probate.
Probate is different. Probate today 75,000 is the court fee stamp,
Yeah.
and plus certain expense plus lawyer fees. Minimum it will come to 2 lakhs with the lawyer fees, and it will take at least 1 year. 6 months, there's a 6 months, because to give the proper detail, we take a lot of time. Then they prepare, then they give us, then they submit. So practically, once you appoint a lawyer, it will take 1 year to get the probate.
So the probate is compulsory in all cases.
That will come. No, sorry. Probate is compulsory for movable or immovable, provided the will is executed in Bombay, Calcutta, and Madras.
Presidency terms.
और
Presidency terms.
दिल्ली नहीं है, ये 3 जगह पे अगर will execute किया है तो it is compulsory. बॉम्बे में it goes to the Bombay High Court.
Yes.
Jurisdiction. Or will is executed outside this territory, but the property is in this territory, then also probate is applicable. And other places no probate.
Situation of the property.
Yes.
Okay.
For Mughal property also, the property is compulsory.
Yeah, well, see, there is a thing. You are given your direction कि my property किस को जानी है, तो जिसको करना है उस without the court's probate, nobody will recognize.
Probate is confirmation only किसको देना है।
Or probate में they don't do anything. They give you the certified copy of the will.
Validation of the will.
Validation of the will. और उसी के लिए ये सब लास्ट टॉपिक अभी आ जाता है, चलो कोई प्रॉब्लम नहीं। तो उसी के लिए जो कैविएट है, जिसको ऑब्जेक्शन है, दे फाइल अ कैविएट, प्रोबेट की हियरिंग है तो नहीं, आई ऑब्जेक्ट टू दिस प्रोबेट, he is not entitled or will is not genuine, there is so many things, so many objections one can take.
So it is applicable like if the person is in Bombay, Madras, Kolkata,
Yeah,
or the property
is in this three,
anyone.
Otherwise will is not there. But
Probate is not.
probate. But I have learned that thing, even in Gujarat, they are insisting, they are not transferring. Practically, they are harassing. क्या probate लेके आओ, probate लेके आओ. You-
Properties in Gujarat and person is in.
नहीं, everything is there. Then also they are doing like this. That's what I have heard.
तहसीलदार का मंगा रहे हैं, तहसीलदार का मांगते हैं।
वो किसी का भी कुछ भी बोलते हैं, but practically nothing is applicable.
Yeah.
But for that also, where will you go? You go to the lawyer. Lawyers are the most expensive.
Yeah, right, correct.
तो पैसा पहले रखो.
So that is the
25,000 court fee है.
Yes.
the court के लिए minimum आपको 75,000 fees plus other expense or lawyers minimum 1 lakh he will charge. In normal lawyer and normal property is the 2 lakhs. If your stake is high,
Charges go.
कोई नहीं करता
लाख में कोई नहीं करेगा, वो 5 लाख रुपया पकड़ के चलो. And that only you go to the normal lawyer. If you go to the solicitor, you know that what are the charges of solicitor.
Standard is 75,000 is minimum.
No, no.
Fix है.
Court fee.
Maximum.
Maximum.
Court fee, not stand.
Court fee.
कोर्ट फी
कोई केस डालते हैं तो लगता है.
नहीं, बट उसमें भी एक चीज है. देयर इज अ डिस्प्यूट, दे हैव इंक्रीज आल्सो, बट स्टिल इट इज नॉट कंफर्म. सो 75 मैक्सिमम है, वो चल रही है.
वो सब सिविल केस वगैरह में देना पड़ता है, सब में लगता है.
नहीं 75, बट इट इज अ डिस्प्यूट. जैसे चैरिटी कमिश्नर में कंट्रीब्यूशन के लिए अभी स्टे है. So like that, this 75,000 is also government has increased, but it is not confirmed till now.
वही ले रहा है.
वो ही ले रहे हैं. तो लॉयर बोलते हैं अगर इंक्रीज हुआ तो आपको देना पड़ेगा. Now another thing is, instead of registration, you can deposit the will with the registrar. That is also that I would discuss the procedure for registration, depositing the will with the registrar. That is governed by section 42 Indian Succession Act to 46. I have given the complete procedure. Basic is there. You have to go there. He will, registrar will satisfy that you are the person. You have to deposit in the seal envelope. Envelope, you have to write your name, address, all details, and the nature of the content. So he will accept that document. Now, after you are giving the will to registrar, what he will do? After satisfaction, he will record in the book number 5. He will seal envelope. He will write everything, the time, everything. He will keep it in the safe custody box. There. After that, if you can revoke the will anytime, you can make any number of, if you want to withdraw, you can withdraw it also. But every time registrar will satisfy everything that you are the right person. And suppose the will is deposited and after the death, the person who is eligible like an executor, he will go there. He will justify, satisfy the registrar, yes, this is the thing, this is the details of the will, register receipt and everything. Then he will take out the will, he will enter in another register, he will make a copy over there, give you the copy and keep the original with him. So it will become your proper will, which a registrar has given you, that it was deposited with me. However, if court orders, then he has to give the original to the court with the order. That is given in section 46. Indian succession.
So this storing of the will by the registrar,
Yeah.
is it chargeable है? क्या इसको भी chargeable है?
Practically कोई ड्यूटी रजिस्ट्रेशन का कोई चार्ज नहीं है.
Keeping the will is the registrar, storage charge.
नहीं गोड़ा चार्ज नहीं है. But you know रजिस्ट्रेशन में क्या होता है, that is a over टेबल कुछ नहीं, अंडर टेबल.
और कुछ
Now let us go to the
But practically, what is the benefit of this?
Because no,
Instead, he can give the directive to the executor, keep it in the.
the point is that the other authority has justified that he has come and deposited the will. So execution of the will is justified, authenticated. So the chances of the genuineness will increase. Suppose, but even if he has not withdrawn, and after depositing the will, if he has done another will, the last will will always prevail. But it has to prove that this will is after that. Because many times it is happening when people come to know somehow, okay, disposition has taken this place, whether I am not getting or getting, and they make a forged will because they know how to sign, and after that signature verify karne hai. And they claim this will is after that, it is valid. So court will give more importance to this and give strict interpretation, the justification and authenticity rules applicable for the subsequent will, which is normal, where executor has been changed, everyone has been changed. So that is why authenticity either deposit, register, or at least notarize with the proper care. Registration with, at that time also you take a video also if possible. So you can prove everything. Authenticity is the most important when the will is contested. Testator, and second will be he was of sound mind, not under somebody's influence, because sound mind person can be under somebody's influence. किसी ने बोला आप मुझे प्रॉपर्टी नहीं दोगे तो मैं ये कर लूंगा. तो बिकॉज ऑफ दैट रजिस्ट्रेशन, डिपॉजिट और लास्ट में नोटरी करके रखना, और डॉक्टर सर्टिफिकेट, डॉक्टर विटनेस, जस्टिफाइड, all those things. And nowadays, if possible, take the video so you can justify there was no coercion, there was no problem. Now coming to the executor, that almost we discussed. Who can be the executor? The person competent to contract, sound mind, even he can be a minor, also can be an executor. Or a major, sorry. The preferred should be the young age. Now the question comes, whether an executor can be a beneficiary. Can you give him the?
Yes.
Yes, it is possible, because most of the time our family members are only executor appointed. Unless the stake is high, we appoint some external authority. We appoint some external authority to be executor, like some institute or like that. Now coming to the part of the witness.
What happens if the executor dies or resigns?
Then anyone who is eligible to get the property or nearest relatives can apply. In that case, what happens?
Apply to court.
To court, but the court will not, that is known as letter of administration. Instead of probate, they will say letter of administration. You have been given letter of administration to administer the property. Even that will also happen. Suppose executor has got the probate, then what has happened? He has administered the part of the property and he expired. Then what? Then someone will apply, then he will get the letter of administrator for the unadministered portion. Now regarding witness, as we discussed, it is most important. Young age, competent to contract, sound mind, even minor can be a witness. Witness can be a minor. And he is not required to know the content of the will, that also we will discuss. Even executor can be a witness. That is also. If you appoint executor, you appoint the same person as a witness. Now, most important person, whether a witness can be a beneficiary, can you give property to them? First read section 67 of Indian Succession Act, which says no. Bequest made to witness or his wife, husband, then bequest shall be void, but the attestation to the will valid. But legatee under a will is a witness to codicil. Codicil is the keeping the main will. Some changes you made by supplementary will. And not a will, then bequest to witness under will is valid. But the most important part is that it is not applicable to the Hindu. This section 67 is not applicable to Hindu.
It can be beneficial.
So it can be a beneficiary for this. But here we have to think of the question for the other than the Hindus. And now Hindu, in Indians and Hindu means Jain, Sikhs and Buddha all are covered. Now, yes, you can bequest to the HF also, but specific declaration has to be there. I will give you the complete section and where it is there, what you want. Nowadays, it is possible, whatever is your share in your joint family property, you can bequest that. So, normally HF, the rule is the survivorship. And here it is the successor. So now for your share, it will be successor, whatever way you dispose of.
No, see, here it says bequest to HF. What I was asking.
Other one also.
My share.
Your step was different. That will also come. So now suppose if you want to give a property to HF, my son's HF, it will go to it will not be his individual, but then you have to make a specific declaration and a drafting should be taken care. He will be treated as a karta, not in individual, and so on. Drafting has to be taken care. But you can give to this thing. And here the chances of multiple HF creation is there, which earlier we used to do it. But nowadays, I don't suggest more HF to be created, even HF, because what happens in HF, if you have property, immovable property, then lot of complication comes after second generation, third generation comes. And how to dispose of? Even you can't sell it. It becomes very difficult. Everyone consent should be taken. Or the money has to be used for the purpose of the benefit of all the members. Suppose आपका एक का लड़का फॉरेन जा रहा है पढ़ने को, उसको 50 लाख चाहिए, आपने वो 50 लाख उसको दे दिया. It becomes difficult. So the wealth under the HUF, I am against that thing. Because today it is, we just see from tax angle point of view. Today we just see only tax point of view. But practical, what happens? Second generation. And today everyone is independent. And everyone is पैसा ही देखते हैं, बाप के पैसा है, HUF में है, सबको ये है. तो avoid, at least HUF create किया तो avoid immovable property. Because movable, it is easily to take out. Though it is my personal view.
Removable property should never be taken in that.
Movable ठीक है.
Should be avoided.
नहीं इमूवेबल तो अवॉइड करो. मैं तो बोला प्रॉपर HUF अगर टैक्स के लिए रखे तो टैक्स के लिए रखो.
तब तो HUF ही नहीं रखे.
हाँ, don't do it. Even I have started partition of the HUF.
हमारा इतने 100% out.
क्योंकि उसमें और झगड़ा बहुत होने को लग गया. क्योंकि second generation, third generation, they never signed any agreement. Then they never come to a conclusion. And everyone is a nuclear family. तो भाई भाई बोलता है कि ठीक है मेरे को नहीं करना है.
आजकल विटनेस में फोटोग्राफ्स भी लगाते हैं, जिससे नेम का
हाँ।
प्रॉब्लम होता है ना, ये वही आदमी है, तो फोटो भी लगाते हैं।
नहीं नहीं, अभी तो विटनेस में तो फोटो भी लगाओ, थंब भी लगाना है, प्लस आपका आधार नंबर लिखो, पेन, सब कुछ, सब this is just identification. How to identify, that is, you have to go by the time.
सिमिलरली बोलते हैं भाई आप राम कुमार शर्मा, मैं नहीं हूँ भाई,
हाँ।
प्रॉब्लम हो जाता है।
So identification is the only key issue. With that passage of the time, you have to move around and prove how you can prove the identification. Now let us see what are the type of wills. Whether will can be oral, it cannot be. Only permission is given to the soldiers, those who are at the war foot, Air Force, Marine. They can make the will orally because they are living in that situation at that actual war ke time pe. Even by chance, if they have got the time to execute, it need not be a witness, it need not be a sign. Since oral will is valid for them, it is known as a privilege will. Under Indian Succession Act, it is known as a privilege will. Otherwise, it has to be. But I'll tell you, and when we come to the Mohammedan law, there is permitted.
तो शादी भी हो जाता है इसमें।
नहीं, oral, तलाक भी oral होता है ना, उसमें सब oral होता है।
How to prove this oral will है?
हाँ? They have their provision.
उनका सर वो पूरा higher authorities।
नहीं वो नहीं उसमें तो अभी जो बात निकला है, even Muslim cannot make a will more than 1/3 of his property. 1/3 ही तो will कर सकता है, 2/3 has to go by successor legal heir. But there is also a sub clause provided after the death, your legal heir gives the consent, then it is valid. More than 1/3 is also. So they have.
If common civil
हाँ, वो
code
सब
comes,
common हो जाएगा।
then it will become common, there will be a common procedure.
Let us not discuss it. We have to understand that.
See, totally, I'll tell you, as far as the Mohammedans are concerned, Indian succession acts are very little applicable to them. They have their own code of and rules, Muslim personal law. Even I have suggested in letter I have covered what property you can declare. I have given the one is the ownership, another is the location. Location, global property you can have. But as far as if you are in the Islamic countries, you have to make the will, you make sure, because Sharia law is applicable. उधर कोई भी वाइफ, कोई भी मुस्लिम बोलेगी ये मेरा ये खाविद है, कुछ भी है, तो सारी प्रॉपर्टी वो ले जाती, उसमें कोई सब ओरल चलता है. That is very, very dangerous. So you make a will as far as in today's world, majority of people will have clients in Dubai. They have to make their will for the special for the Muslim countries, Islamic countries, get the registered will as per their rule, then your properties are safe. And one make for the global property. For Islam countries, it is very difficult. You have to be very alert. Because mostly Dubai में अभी क्या है, property भी allowed हो गई है. You can buy the property. पहले property allowed नहीं थी. You have the properties. You have everything. All monies are over there.
Foreign property, so then probate will be from our court or from their court?
There is a provision. I covered that thing. Where for as far as the immovable property is concerned, the property where it is situated, the rule of that country will apply. Movable property, rule of domicile will apply. And suppose you have made a global property, one is for the second for your Dubai property. You are in UK. You have made will in UK. So if you have executed will in UK, the property may be anywhere. You obtain probate in the UK court, which justified that yes, signature, witness, everything is there. Then in India, you need not apply again the probate, but with that probate, you have to get it justified. There is some different procedure, but it is very convenient. Okay, that probate they will endorse it. It is known as sealing of that probate. At least UK and India, that is there. The probate where you have executed the will, that will apply. But for the properties, wherever it is situated. Now joint will. That is by two or more persons in single document. They can dispose of their separate property as well as joint property. It operates separately and independently. Such will operate independently on each testator's death. It's a single document. Whatever you have disposed of your individual or joint property on death, will applicable to that person will become applicable and others will remain there. Even it is revocable by them. The main thing is that two people together in one document, they are disposing of same property. Now, can you make a discretionary will, like a discretionary trust?
In joint will, one question is there.
Yeah.
In Mumbai, like that, first name is of the husband.
That is different. I'll come. This is joint will.
100% making the payment.
No, there is a separate issue I have taken cover. No, this is the, while making a will,
They can enjoy and supplement.
will have. Oh, joint
That is
property,
joint property.
a joint will, two people in one document.
Others,
और खुद की और joint property दोनों कर सकते हैं.
single is always preferable.
It is always preferable, but many people
Separate.
this is the for discretionary will, law doesn't recognize the discretionary will. However, you can make a clause that I am giving this person all this property to him to distribute as per his wishes to so and so people. That discretion has been given to the one person, that is allowed. So it is possible to bequeath the properties to a person and then provide that he should distribute the same among certain person in proportion he thinks fit and proper. So indirect discretionary you can create. Now the question, most important question, if you have no will, person died without making any will, what will happen? अब इतना तो कहता है will करना ये करना. The property will go by the succession of the your personal law. हिंदू के लिए हिंदू succession है. For Christian and Parsi, Indian succession act है. For Mohammedan personal law hai. So what happens? If you desire to give to someone, it will not happen. It will go as per the legal hair. And that will discuss in legal succession when it comes to whom it goes and how it happens.
What about the Sindhis?
Sindhis are Hindu. See, Hindu is covered Jain, Sikh, and Buddha. Hindu covered all. Parsis are not covered in Hindu.
Hindi is not a dharma. It is like Gujarati. Now, Gujarati person can be.
You see, in Gujarat, many Mohammedan people speak Gujarati.
Hindi, a geographical.
He
it is not.
he asked the Sikh. He asked the Sindhi. Sindhi, not Hindi. Sindhi.
Hindi is a geographical term. It is not a religious term.
सिंध से आया उसको सिंधी बोला,
ये geographical का।
कच्छ से आया उसको कच्छी बोला,
हाँ।
गुजरात से आया उसको गुजराती बोल दिया,
तो हिंदी का
मारवाड़ से आया उसको मारवाड़ी बोल दिया.
बोलते उल्लासनगर से आया तो सिंधी.
See, in India, lot of confusion has been created. One is the regional identity has been created. जैसे आपने बोला सिंधी, गुजराती, मराठी, महाराष्ट्र तो आया तो महाराष्ट्रियन हो गया. सेकंड इज कास्ट वाइज कर दिया. थर्ड इज धर्म के हिसाब से कर दिया. सो अल्टीमेटली व्हाट यू हैपेंस यू जस्ट सी, अभी अब इधर हो ना, आप बोलोगे मैं गुजराती हूँ, मैं मराठी हूँ, महाराष्ट्रियन हूँ. आप इंडिया से बाहर जाओगे ना, आप बोलोगे मैं इंडियन हूँ, कभी आप इंडियन हो जाते हो. उसके बाद थोड़ा आगे गया ना, बोलो मैं एशियन हूँ, एशियन कंट्री हो गया, बिकॉज दे आर नोन एज एशियन कंट्री हो गया. तो लाइक दैट अपना वसुधैव कुटुंब जैसा ही है. हमने ऐसे ऐसे सबसेट 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 करके गए. Now, what property you can bequeath? Movable as well as immovable, both is covered. You can make a will for both of them. Now, property is divided by two. One is the ownership and one is the location. So, ownership only the property which you are the owner, that can be disposed of. If you dispose of somebody else's property, it won't be there. As I was discussing, practically sub-client came. He was the only earning member. Or sub properties, everybody's name he started taking. He said, मेरा will बना दो, प्रॉपर्टी का लिस्ट लेके आया. अरे ये प्रॉपर्टी आपकी नहीं है, वाइफ की है, इसकी है, आप नहीं. अरे सब प्रॉपर्टी तो मेरी है, तो मैं क्यों नहीं कर सकता. So you need to educate them. It is always, you know, the family of the client. You discuss with them because he may have some reservation. उसको बहू को देना है कि बेटी को देना है, कि बड़े लड़के को देना है, छोटे लड़के को देना है. We just thought कि चलो फैमिली है, सबको देना है, तो सबको कैसे देना है. आप उसको इंटरेक्शन करते जाओ 2 घंटा 3 घंटा, then he will open with you. Then you will come to the real cause. उसको क्या करना है, कैसे देना है, कैसे नहीं देना है. And then you give that, you can't do this, you can do this, you can do this. और प्रैक्टिकल व्यू भी also आपको देखना है कि डिस्प्यूट कम हो, क्योंकि डिस्प्यूट होने से सारी प्रॉपर्टी अटक जाती है. अगर एक किसी ने भी कोर्ट में कैवियट डाल दिया, तो वेयर आवर रोल इज देयर आल्सो टू एक्सप्लेन द प्रैक्टिकली कि आप ऐसा मत करो, सबको इक्वल दे दो, बेटर है. जो थोड़ा ही डिफरेंस है तो समटाइम्स ही मे फील इट, ही मे हैव द लिव इन रिलेशन कि मेरे को उसको भी करना है. यू टू टेक प्रॉपर केयर. जब बाद में आएगा, मैं आई हैव कवर दैट थिंग. व्हेन यू आर नॉट गिविंग प्रॉपर्टीज टू योर लीगल हेड्स and family members, but to the outsiders, you have to give very, very reason why I am not giving to these family members. Otherwise, it will be prone to challenge, but to sustain if you have not given the reasons.
Is there in the will?
Will. You have to give why I am not giving my properties to my legal heads, my family members, and why I am giving to someone else. Why I am doing charity also. Otherwise,
In case of a demat account, when there are two joint holders.
the shares का बहुत issue है. Shares के लिए I will come when the nomination comes, no. नॉमिनी का पॉइंट आएगा, उसमें आएगा.
इसमें my only question is that If it's in the joint name, then is the first owner.
वो मैं नीचे एक पॉइंट कवर किया है हाँ अभी वो वही आ रहा है अभी सो
Husband has purchased the property in the name of wife.
just wait I'm coming then
Sure, sure.
your question will be covered otherwise you ask me now must be owned by you maybe a single name if it is joint name you can bequeath only your share whatever is entitled to you but in case of second holder name is for the convenient purpose the money has been contributed by you normal property rule is that whoever is given contribution to the property purchase he will be owner to that extent if 50-50 50-50 20-80 20-80 the ownership will go like that if it goes the matter to that if it is other way you have to write in the purchase of agreement irrespective of the money contributed by the rights are 50-50 or like that if it is specified then this you have to specify also that this property is my but second name is for the convenient purpose if you have not written that but you prove that all the source of the investment is one person second name is only for the joint holder then you are allowed to make a will for the 100% of that thing but in
You find your property from a builder, will you allow you to make this changes in the agreement?
see builders are dictating unka to ready draft hai so but then the source is important no how much contribution who has made to the builder suppose नहीं the bank account आपका अकाउंट से गया पैसा आपका है हाँ see
प्रॉपर्टी का पैसे भी संभाल के रखते हैं जब भी खर्चा करते हैं तो
टुडे
भी आता ही है ना वो बैंक स्टेटमेंट रखना चाहिए
बैंक स्टेटमेंट रखना चाहिए सब
भले
कुछ
50 साल का।
के प्रॉपर्टी परचेस किया था वो आपका ही पैसा था आपके अकाउंट से गया वाइफ के अकाउंट से नहीं गया क्या सेकंड होल्डर के हिसाब से नहीं गया है then you will become declared the owner if someone has also paid the money then he will also become part owner so whenever it is like that you are the first owner 100% second name is convenient you have to put such sort of clause which I will given, I read out. I declare that all shares, security, bank account, fixed deposit, and other monies which shall stand at the date of my death in joint name of myself first, and in respect thereof, and my family members, my name standing first in respect thereof, belong to me absolutely and shall form part of my estate on my death. The name of my family member having been added thereto for the sake of convenience and facility only. However, all shares, security, bank account, fixed deposit, and other monies which shall stand at the date of my death in the joint name of my family member and myself, wherein their name standing first in respect of thereof, are and shall be their own property, and my estate shall have no interest therein, my name having been added thereto only for the sake of convenience facility. Such thing is to be drafted over there. This is just simple, but case to case you have to remodify.
Because certificate one is to prove. See,
No, no.
whatever I may write.
No, you have to prove it.
Taj Mahal is mine.
No. What I mean to say, you have to prove it. But when Hakikat,
Does it make any difference? What I am trying to ask.
no, it makes a difference in a sense. You have stated this and you are doing it. Then to prove it, without this thing, it will have is that the
Additional burden.
additional that you go in.
There will be additional burden.
Then what will happen? Someone has to go and challenge. If you don't put it, prima facie, the court will say.
See, even if I bequeath anything, it is presumed to be mine only.
Yes.
So if somebody is disputing, in that case also that person will have to.
Correct.
So only declaration will.
This is not
According to me,
100%.
it will not make
It is not the full proof. So that's the same thing. When you see, when you write, I make this will in my proper state of mind, and without undue influence. But there can be undue influence. The same way, it takes a precaution and it gives the cursor moving that, okay, this is the situation.
Sir, I want to fix this. The property is purchased by Mr. X.
Correct?
It is his own money, 30 years, 35 years back. If the property is purchased in the name of Mr. X, Mrs. X, and his brother Y. Agree? Now that Mr. X has died, now the society is asking whether Mr. X has contributed money. There are the three owners in the share certificate also. Now, wife wants to transfer this particular property in her, it is a Cindy. So society is asking, give us the proof. Now, how to prove it?
Society cannot ask. Society cannot ask. Probate लाके आप कर दो. You see, the dispute is among the joint holders. कि किसका property है, किसका नहीं है. तीनों का नाम है, तीनों का property है. It is presumed. Normal presumption is that जिसका नाम है उसकी property और one equal share. This is the normal presumption unless it is proved other way. What he is saying, जिसका नाम है उसकी property सबका equal. This is the normal presumption. Unless the right to dispute is two owners only. Outsiders cannot dispute.
Now there are only two owners, their brother and the wife.
Ah.
On paper.
The person who died is legal heir.
His legal heir will step into his.
No.
Can be two owners.
See, listen. एक मिनट में उसको आपका बात. What has happened? जो जिसके नाम पे था वाइफ और भाई, अभी जो गुजर गया, उसने विल बनाया है कि नहीं बनाया? विल किसको नाम क्या किया?
It has been given to the wife.
Wife.
Mrs. X.
So now with the will, and there is a certain society's procedure also for the legal head to transfer without going to the court. Therefore, without going to the court, there is a certain procedure.
Probate is mandatory if that is required.
The probate is mandatory, but still society can do it.
Society has no power to do it.
There is a procedure in bylaws. You read, there is a procedure given. So now we don't go for. So once you obtain the probate, accordingly, his share will go to the wife. Court, society code, you give the probate, give all the compliance with all the formalities. They will transfer they will delete one name, become the two names, but ownership will be 2/3 and 1/3. क्योंकि husband का wife को गया.
I don't want to transfer it in the name of the brother.
नहीं, उसका तो रहेगा ही. His name cannot be deleted.
It is not their wife wants and.
See, brother का नाम है, society cannot delete. Society cannot delete somebody's name from the share certificate.
Probate is mandatory in this case.
Probate is mandatory as no. Probate is mandatory.
But if there's no legal dispute, wife is okay with the 2/3, brother is
That's
okay.
what I understand. I'm not sure on the society's rule,
No,
but
I'm saying just generally.
general, I think there is some provision is given. Certain.
There is no provision, but probably you can lay, already it is discussed that in Mumbai,
No, I heard that.
but that's all.
No,
That-
but that's
Then
actually.
it is mandatory. It is mandatory.
That means one of the will in Mumbai can be without probate, even if there is no legal dispute.
It's not basically, society can transfer. There are procedures for transferring, society are general transfer, they are not asking for the probate. There is no rule as such the society transfer, ask for a probate. And there are so many.
See, that will leave it for the society expert.
If the register wills are given to the society, they transfer it.
See,
Yeah.
no, nominee, there is no nominee. We are discussing about the legal head.
No, even if nominee is there, they are only kind of a trustee, they don't become. owner.
नहीं, वो बाद में आ रहा है. वो नॉमिनी का बाद में आ रहा है, but nominees are the trustees, that is correct. नॉमिनी का ट्रांसफर का तो इश्यू नहीं है, वो तो कंपल्सरी सोसाइटी को ट्रांसफर करना ही है, वो हो गया. बट नॉमिनी इज ड्यूटी बाउंड टू ट्रांसफर टू द लीगल हेड. But what is there? There is no nomination, but the will is there. We are discussing that. So it depends on the housing expert. But what I know that there is some procedure is there where society can transfer. But it depends on committee to the committee, society to the society. What he says, इनकी society में होता होगा,
Oh, see, anything can happen.
because they may not be knowing the rules.
They, and whether they, whether if anybody challenges, then it doesn't stand.
Ah.
Okay,
No, no, what I
Otherwise,
mean,
everything happens.
so my point,
So in the normal course, if you're making a will in Mumbai.
Yeah.
Normal course, forget about the society.
correct.
You still need to provide.
Yes.
the will.
Yeah, yeah.
Yes, it is-
See, the probate, because no court will take cognizance of the will unless the probate is obtained.
Correct, but that is
So-
only the legal dispute.
No,
There is
no.
legal dispute expected.
It is not valid till the probate is done. It is.
See, that is
only after
distributed
probate.
See, see what will happen. Dispute आपके अंदर नहीं है, but my liability is there. To whom I should transfer? If I transfer and he is not the rightful owner, then I am responsible. I am not discharged, and that is why the nominees require. My duty is over if I transfer the nominee. Then आप आपका देखो कौन legal है कौन नहीं है वो आपका मतलब हो गया. I am discharged. That is the role. Why now everywhere is asking nominee करो, nominee करो, nominee करो.
So
There is
that is
the-
mandatory, as per the law.
हाँ,
Nomination is mandatory.
और म्यूचुअल फंड सब में अभी चालू किया है.
Housing society, it is for years.
No, no, compulsory नहीं है.
It is mandatory.
No, no.
Now you have to report a report to that, how many nominations are issued, how many are pending. You have to report
It
in
is
the report.
mandatory under Maharashtra Cooperative
Under the
Society.
bylaws, it is mandatory.
It is mandatory under the.
तो अभी काफी जगह पे मैंडेटरी सब कर दिया, म्यूचुअल फंड सब में भी कंपलसरी कर रहे हैं ना. Otherwise,
But here it is
आज
for decades.
In society, nomination is for the benefit of the society, not for the benefit of the heir.
No, no.
Because society wants one person to deal with, so they can deal with the nominee.
no, another
But heirs
another-
do not get
no.
any benefit from this because he is the nominee. he is the-
another point is there. सोसाइटी को तो हो गया 1%, बट आपको नॉमिनी को ट्रांसफर हो गया विदाउट गोइंग टू द कोर्ट और एनी असल. Then what happens? Suppose there is an intestate successor. All the legal heads are coming to a conclusion and they make a release deed in favor of someone. They get the release deed registered. They submit to the society. Society will transfer to the person whose favor you have the release deed. So what will happen? Without going to the court, the property has been transferred. That's what is your question, is there?
Yes, in the instant case also, society law has done the same thing. Take the release deed of the brother
Huh.
and I will transfer it.
Yes, that is the. So what has happened? Nominee, then release deed, get it transferred to the one person, whatever you come to conclusion, release to two people, whatever is there, all legal head will come and register the release.
Prove that all have come in release deed.
Yeah.
That is the issue. That is why probate becomes mandatory.
No, no.
Because see, the moment you say 5 people have done, 6th one will say I am also.
वो तो probate.
Public notice in Hindi.
No, no, no.
It must be final.
Atul,
That is why
Atul.
probate is mandatory.
See, I am talking about the intestate successor. Then release.
No, then succession certificate is the way.
Then a letter of administration is made.
Then a letter of administration is different. There is
Yes, it is
success.
mandatory in
It
case.
is succession certificate comes. Not
Succession
letter.
certificate is
And a
there.
letter of administration comes
Oh.
in that case.
Now, question is there. कितना लीगल हेयर है वो तो आपको एफिडेविट करके ही बोलना है. वो आप नहीं बता सकते हो कि आपके कितने भाई बहन है कौन किधर है. तो कोर्ट में भी बोलो या इधर बोलो तो
But
मतलब
court
क्या.
is the authority, while
नहीं.
the office bearer doesn't have the authority.
No, office bearer, they take the affidavit, they take indemnity. So accordingly release deed is, because ultimately who will give the certificate?
Because poverty.
See, affidavit, what is affidavit? You go to the court and swear it there. That becomes the affidavit in the court. So if you file wrong affidavit,
That if somebody is, lying before the court under the oath, it's a criminal.
So,
Why?
no.
Anybody, does it
नहीं तो मैं वही बोल रहा हूँ जो affidavit, no. So when I am making a release deed and I am filing the affidavit, I file the affidavit in front of court. Instead of notary, I go to the court. So it becomes the same. In even normal affidavit, if you file wrong affidavit, straight आपको जेल में डाल सकता है. The affidavit rules is there, you know well. So whether court or no court, notary, no notary, if prove that you filed a wrong affidavit, you are gone. So once the affidavit is there, it is normally prima facie, you go and accept it. That's the rule. हाँ, नहीं पूरा होगा फिर.
एक नंबर चल रहा आउट ऑफ 23 तो सब रह जाएगा. क्वेश्चन लास्ट में नॉमिनेशन में बहुत बात करनी है.
नॉमिनेशन में वो शेयर्स का है ना बहुत डिस्टर्ब कर दिया. जो इक्विटी शेयर्स है ना, ओसवाल एग्रो का केस हुआ 2020, उसमें कोर्ट ने जो रिमार्क पास किया है वो पूरा सेटल लो अनसेटल कर दिया है. बट जजमेंट नहीं है, रिमार्क डाल दिया. इट हैज गॉन थ्रू वन इन सिंगल जज बॉम्बे हाई कोर्ट. They have, as far as the shares are concerned, equity rules are different. Nominee is the beneficial owner. Then Salgaonkar case, single judge, they overruled this case. Different single bench, different judge. Then division bench of Bombay High Court in SD's case, they held no, nominee is a trustee. It was all settled. No, नहीं ऑफ सेटल हो गया, बट दैट हैज बीन पेंडिंग इन द सुप्रीम कोर्ट. बट टुडे इज पॉसिबल कि बॉम्बे हाई कोर्ट का है बराबर. अभी सुप्रीम कोर्ट का एक 2020 में जो जजमेंट आ गया अरुणा ओसवाल का, उसमें इश्यू क्या किया, कोर्ट हैज नॉट डिसाइडेड दिस इश्यू बट गिवन ए वेरी क्रिटिक रिमार्क, नॉमिनी लीगल ओनर है.
लीगल ओनर है,
हाँ
सुप्रीम कोर्ट से.
हाँ, बट इट इज अ remark only, not the judgment.
That is why in Maharashtra Cooperative Society
Amend किया, section 30 amend हो गया.
they have very specifically now mentioned
Now mention.
that nominee are only.
But is there a society? I am talking about the company's equity. So उसमें भी क्या क्या कोर्ट और सुप्रीम कोर्ट का फाइनल वर्डिक्ट वाज इन डिफरेंट एंगल, बट दे पास दिस रिमार्क. हाँ, but how far is applicable, it becomes difficult.
Sir, currently there is no Supreme Court judgment settling the position saying nominee is the trustee or the owner. There is no such judgment till date.
बॉम्बे हाई कोर्ट से सेटल हो गया था. अभी सुप्रीम कोर्ट में अभी जो आया है ना 2020 में, वो एक पैरा उसमें क्लियर कट लिख गया है, उससे पूरा अनसेटल हो गया है. बट नाउ व्हाट हैपेंस, एनी कोर्ट विल टेक एनी स्टेप. अच्छा, now ownership is over. Now let us go for the location. वो भी काफी थोड़ा थोड़ा कवर तो हो गया डिस्कशन में. You can bequeath your global property wherever is situated. अरे एक मिनट. हाँ हाँ. You can bequeath your global property wherever situated, but it is advisable to make two separate wills, one in the country where you reside and one is for the rest of the country, because it will help you for the smooth passing. Now, for NRI,
means who will मतलब last means you will have to mention that simultaneously.
yeah, the two separate will, but you have to mention this is for Indian property, and I am making some will for my other property separate will. The cross reference is to be given.
Otherwise, it will be taken that last will be the final will.
No, you have to make this is only my Indian property, and you pass a remark That for my other global property, there is a separate will.
And there also.
There we make a cross reference. So whichever is first or second doesn't arise. So there it will go like that. But and for NRI, the country where he is resides, not for the India. For Indian and the global. But suppose you are staying in Dubai or anywhere, London, you make separate property for that and then the global. And for global, India should not be a separate country. Now, the most question what we discuss also in Islamic country, you have to take a lot of care as most of the we have our clients in Dubai base. So there the Sharia law is applicable. You make whether global का बनाया नहीं बनाया वो ठीक है. You make for your Islam countries will as per the prevailing rules of that country.
Even if he is a Hindu, then also Sharia will be applicable.
Yeah. Sharia is very dangerous. So, if you remember, FEMA के पहले फेरा था. फेरा में ऐसे बोलते थे ना कि if you offer a cup of tea to the foreigner, it's a violation. कोई foreigner आया आपको चाय पिलाए वो violation था. It was that draconian. The Sharia is like that. आपकी प्रॉपर्टी है, कोई भी मुस्लिम औरत बोलेगी ये इसके साथ मेरा रिलेशन था, ये तो मेरा खावित हो गया था, ले लेगी. उनको कुछ प्रूव नहीं करना है. आपको आपके ऊपर है, आपका लीगल है क्या करेगा. और मोस्टली आप है तो आपको नॉलेज है तो आप फाइट करोगे. फैमिली मेंबर्स कहाँ कहाँ घूमेगा. So always advise your all people, those are Islamic countries, make specific will. Even उनके आज प्रॉपर्टी कम भी है तो भी ओवरऑल बना दो. आज present and future also whatever at the time of that whatever he will have in that country, you can make the future also because property always keep on changing. So you have to say at the time of death, whatever the property I have.
That will has to be made and registered in Dubai.
Dubai, yes. My many clients have registered. They go there and get registered. Even when they made a global will also, no? They go to the Indian embassy and get it there for global will also. They executed in Dubai, but for the global property. They go to the Indian embassy, get it arrested and everything there. And for Dubai property, they get registered over there. अच्छा, now question is coming. जब ये global property है ये है तो which law will govern for immovable property wherever it is situated? That will be applicable. For movable, law of domicile. Domicile means where you reside or where you intend to reside permanently. Temporary for your service if you have gone outside and serve, which will not change your domicile. Serving outside city, temporary no. Permanent residence should be there or your intention to remain there permanent.
In case of dual residence.
This is the domicile where you are residing.
He has a what is a passport? Indian citizenship as well as US citizenship.
No.
That is not there, but where you no, but where you are residing, where is your intention to reside? The point, what is here? Domicile, where you are residing and your intention to reside permanently. You can't say that permanently मैं दो जगह पे रहने वाला हूँ.
See, he has a what is a any property, 4-5 months he is staying in India, 4-5 months in USA, 4-5 months Singapore, like that.
But your intention is there. Where is what you consider?
Somewhere is your Singapore is India.
So you have to decide where. So there, domicile will decide. Now coming to the FEMA provision. Because at the time of making will, no FEMA is because you are just making a dispose of the property is not disposed of. So after the death, when execution comes, that time the FEMA provision will come. So if you have bequested the Indian property to Indian, no issue, but to outside. Let us say Indian property you have given to your son who is staying abroad. He might have to take RBI permission to dispose of. But to my knowledge, in 2000, there is a one declaration. If you have inherited the property up to 1 million, it is inherited up to 1 million, you need not take the permission.
Maybe it is liberalized scheme, but here there is no restriction. Once
No,
you
no,
know this is done and 15 CBs given,
15 CB is income tax. 50 CB is income
but
tax.
that has to be given. So this money can be remitted, whatever is there.
Now the question is, he is a foreigner then. So lot of FEMA provision you have to take care while distribution of the property. प्रॉपर्टी दे दिया, उसके नाम पे चढ़ने के लिए और पैसा उधर लेके जाने के लिए you have to go through the FEMA provision at that time whatever is prevalent. Now question comes, can you bequeath the liability? अरे मेरी liability है मैं आपको देता हूँ.
To the extent of, yeah, to the extent of.
तो आप simply liability you can't bequeath because you are disposing of the property. But you can relate with the property if you say, I am giving you so and so property to Mr. X. Some liability attached to that, whether mortgage or otherwise my other liability which he has to discharge, then only we will get this property, then it is valid. In that case, he has to accept both property as well as obligation. He can't accept khali property or if he doesn't accept, the bequest is void. In that case, you should take provision in the will. In such case, what will happen? This property should go to him. Who? Or it will become part of my residual property. It is up to you. Whether, but you have to specify if any bequest becomes void, what should happen? How it should be disposed of? What is your idea? What is your desire? How it
But
is to
even
be?
if that is not bequeathed specifically to any person, it automatically becomes residual.
But provided you have made the clause in the residual, that is also important. Residual provision has to be made. And it is most important in residual property clause should be there because the property keep on changing.
Yes.
If some properties are added and you have not changed the will, it form part of the residual property. And if residual clause is not mentioned and there are some properties which is not disposed of, it go by succession, intestate.
If the liability is more than the property, then can you block it by stating that the liability should?
You don't accept, you don't accept, don't accept.
So can you make a statement stating that in case this liability is restricted up to the total value of the property? Or
It automatically it is.
That can be done, but
Both will go together.
but even you have to make as a general provision that my liability should be made out of my property. Then balance should be distributed. See, normally we make that my funeral and all ceremony expense should be first made out. Like that, we make provision for the liabilities also. Like that, we have to make a provision if any professional fees are required to pay to the executor.
that is to be made out of.
To mention, even to the lawyer also you have to pay the fee. You have to mention that out of my estate first with all this liability, all expense, then it should be distributed accordingly like this.
So if the liability is not mentioned, only the property is mentioned, saying property is given. Then the liability automatically doesn't shift to the person.
No, but then what happens? If liability is attached to the thing,
It's not attached. That
No,
is
no.
distinct
it is
from-
related to any particular property. That person is liable, and the liability is he can claim and go to the court and say, okay, you have to give it to the extent of the property which is inherited.
If it is linked to the property.
Otherwise, also, the person will go to the court, say, out of total property, let heads should break their head among them.
Who will bear it, right?
I want my say out of all this property, and feel let them break their head कि किसको कितना share है किसको नहीं है. He has right to from the property to obtain, but for that he has to go to the court.
Then you can claim from the legal heirs.
He has to claim for the legal right from
Legal and personal.
Legal-
not personal,
Estate of them.
only whatever they have inherited. Now question comes to the bequest to the unborn person. Can you give property to unborn persons?
Yes.
General rule, no bequest can be given to the person not in existence. There cannot be a vacuum. But there are two exceptions they have provided. Prior bequest should be there. There has to be a prior bequest in favor of existing person preceding the bequest to the unborn person, standing in particular degree related to that individual. Then it is okay. Second is there. There is no prior bequest, but you are defining a particular event that Mr. So and so alive उसके के बाद इनको जाना चाहिए, but उस time वो होना चाहिए. Like that, possessor bequest is deferred to such unborn person until time later than the death of the testator. In such case, person answering the description is alive at the time or come in the accident between that event and after. The bequest go to such person, though not alive, then it goes to his representative. And this I have but in both the case, that bequest to one person should be total. It cannot be for a part. Bequest to unborn person is void unless it is for the total remaining interest of the property. Because you can give life interest to the also property. You can say that this property is given to Mr. X for his life, then to his son, though at that time he may not be married also. But at the time of the death of the Mr. X, he has a son, is good enough. But to unborn person, it has to be, you can't say I'm giving to Mr. X for life, then unborn person is son for life, then to someone. You can get 2 times life, Mr. X to life, then Mr. B who is alive for his life, then to son of Mr. X, but that X is not born, then it should be total. So that what I have explained by 2 examples, which I am not taking because of the time, is very simple. You can read it. Simple. Now there is one point is also the rule against perpetuity. You can't defer your property bequest indefinitely. The life of one person and the age of majority. No bequest is valid whereby the vesting of property is delayed beyond life of one or more person living at the time of death and minority of some person. It cannot be more than 18 years deferred. If you say given to Mr. X for life, then his son, he attains the age of 25. It may happen Mr. X son, when Mr. X expired, His age of only 2 years. So when he becomes 25, it is more than 18 years. So that is void. It should not be more than 18 years. That's the whole perpetuity. That also I explained in 3 examples. Now another point, Hindu Adoption and Maintenance Act. In case of adopted child, if you inherit some property and that person has not received any property, then dependent person not receiving any property, that person has to maintain him. Obligation on the heirs receiving the estate of the deceased, either by intestate or by a testamentary succession, to maintain dependent of the deceased out of the estate received if such dependent of the deceased have not received any share in the property. Now, I just discussed the mother-in-law, the only few points. Mohammedan cannot make a bequest by will of his entire property unless the consent to the said bequest after death is obtained. Now, Mohammedan cannot dispose of more than 1/3 property that we discussed. And if he dispose of more than 1/3, the consent has to be given by the other people, legal heads, then it is valid, otherwise not valid. The will may be oral or may be in writing. Here, we are not allowed oral will, but they can have the oral will. They need not be signed. There need not be attestation, which is mandatory for signing and witness attestation. Without that, our will is void. Here, it is not there. In short, no formalities. There is an absolute prohibition against making any request to unborn person. जो अपना exception है वो भी इधर नहीं है. Except to a child in womb. That too, he is born within 6 months from the date of will. That is also a condition.
From the date of,
From the date of will.
not death.
No, no. Now, general, what are the laws which are applicable? As far as the personal inheritance law is concerned, Hindu Succession Act, Indian Succession, and Mohammedan law. These are the because Indian Succession Act will cover Parsis and Christian. Transfer of Property Act to some extent will be applicable. Indian Registration Act will be applicable as we discussed registration of the will or deposit of the will. Indian Trust Act is applicable because if we come later on whether we can create a trust by way of will. If it is a private trust, then Indian Trust Act applicable. If it is a charitable trust, then in Maharashtra, it is Bombay Public Trust Act. But respective, accordingly, you have to apply. Because charitable trust, it depends on the state-wise. And income tax. But we are not covering to the income tax, which go again it is separate. So, Christian, Parsis, Mohammedan law, income tax, we are not touching today. Now, trust by making a will. We can create a family trust or public charitable trust. Yes, it is possible. Trust will come into effect only after the death of the testator. That is a normal rule. Everything comes only after the death. Before death, it is invalid. Now, family trust. Here, Normal case में discretionary trust if you make, the taxation is very difficult. Maximum rate is applicable nowadays. But by way of which you are making only one trust. It is possible and the taxation is not at maximum, it's a normal. Also, if you carry on the business by that private family trust, then also taxation is normal, provided it is for the benefit of the dependent family members. So discretion, it is discretion as to the income and as to the corpus. So which is not discussed. Now coming to the charitable. Can you make a charitable trust by of will?
Yes.
Section 118 of the Indian Succession Act says no. They have given the conditions. No man having a nephew, niece, or any near relative shall have power to bequeath any property to religious charitable use, except by will executed not less than 12 months before his death and deposited within 6 months from his execution. 12 महीने पहले होना चाहिए और 6 महीने पहले डिपॉजिट करना चाहिए. Then on, and it is valid. And this is not applicable to the parsing. This, but Supreme Court has struck down this. It is violation of the Constitution, fundamental rights. So you can make it. It is there still in the statute. But Supreme Court, I have cited the judgment where they said this is violation, discrimination. So now it is, we are allowed to make a charitable trust. But while making a will, I mean trust, you should be very careful. Either you have to specify for whose benefit, who will be the trustees, what properties, everything has to be specified over there. It is always better you can draft the complete trust deed and attach as per this. Both the way. Otherwise also be specific. Now, as far as the private trust is concerned, people are going for it. The reason is there. The property is distributed at the time when it is required and to whom. Suppose there are 5 family members. Some member has proved wrong. He doesn't desire anything. जैसे बताया ना, he become a vagabond. उनको कुछ नहीं देना है. It is possible. किसको ज्यादा देना है? All are not maybe same. One may become enough wealthy. Others are normal. So trustee will decide. That's the whole idea. But here the practical example I'll tell you, which I'm facing, though they are not my client, they have come to me. They have executed private family trust. They trusted the one persons. The 3 daughters and other 1 CA and 1 their family person. 5 को ट्रस्टी बनाया था. सारा पैसा जो था ट्रस्ट का, वो जो एक ट्रस्टी था अदर देन द सीए, उसकी कंपनी में लगाया. वो इंटरेस्ट देता गया पहले, और इट वाज फॉर द बेनिफिट ऑफ हिज सन. He was mentally retarded and in the USA in the institution, because in that sense he even killed someone in family. So all such things were there. Slowly, somehow, the person who is having money is finding liquidity problem. Initially started accumulating the interest. का interest अभी जरूरत नहीं, जितना जरूरत है उतना पैसा देता था, not giving money. Now the dispute has arisen and it has gone to the court that he is not money. And lot of technical problem comes. Whether probate उसने लिया था कि नहीं लिया था, ट्रस्ट डीड बनाई थी, ट्रस्ट में क्या लिखा था, विल में क्या लिखा था, अच्छा, उसके बाद वो CA used to make the accounts, everything. A dispute हुआ, he resigned as a trustee.
But you can limit right where it can be invested and all that.
No, उस टाइम अगर आपको पूरा भरोसा है, आपको दिया और ट्रस्टी भी आपको बनाया, बट उसमें और बहुत सारी क्लोज है, तो वी आर टेकिंग बेनिफिट ऑफ दोस थिंग कि नाउ वी नीड टू बाय अ प्रॉपर्टी बिकॉज टू ब्रिंग दैट सन बैक टू इंडिया, you give money, and now because you become the vested interest trustee as well as the money you are having, which you should have avoided, because पहले पैसा उसके पास ही था बिफोर द डेथ, उसने वो घुमाया, ट्रस्ट में वापस ले लिया. Now, certain important thing, what should be in the will? Writing, as we have discussed the testator's signature at proper place, attestation, witness. We have discussed that it should be disposal of the property after the death. This is the 100% required. Now, suggestible. जब ये बात चल रही थी, you appoint one or more executor jointly or alternatively. You got the answer. Joint or alternatively. Then suppose the will is there, the testator is not familiar of this language. Will is in the language where testator is not very familiar of it. At the bottom, you have to write, it has been explained to so much, this is this, and this. In this, her language, her or his language, which he understands. If stressing bequest to legatee to state what if legacy is renounced or is dead. Suppose will के अंदर आएगा पार्ट, देन जो सिग्नेचर आएगी उसके ऊपर ये आ जाएगा, उसके नीचे विटनेस भी आएगा.
Then you will have to mention who is explained.
Last para में is to mention that this has been explained.
Sure. Very right. I understood it.
Explained means
One.
it's a passive voice, it has been explained, or it is explained to me by so and so, like that. No,
I have explained the contents of this will to the testator in his mother tongue,
Yeah.
and he has signed in my presence and in the presence of the board testator. And then I sign the chapter.
Yes.
So that in that case,
The
the
person,
contents of the will get known to
the person who has explained.
witness of.
No, witness. The person who has explained, he will put his signature. If the third one, testator, witness, and someone.
Apart from witness, there will be another person.
Yeah.
Who will be explaining.
Will be explaining. Even, I think we have skipped because of the timing and other discussion. Suppose there is a shaky signature. बराबर sign नहीं हो रही है. Is valid because witness will justify. This was the situation, the signature cannot be 100% the same. When dispute arises, all these things comes. So witness part is most important. That's why I said it should be young and the doctor, so they can justify everything. Their statement will prevail. And they should be so honest, integrated, that they should not have a fear of pressure. So what happens if someone renounces? If somebody is giving me the property, I say, no, मेरे पास enough है, I don't want. Then what happens? Or जिसको दिया वो है नहीं. He passed on before the, you have to make clause in that your will. In such case, what should happen? This property become part of my residual property, or if he renounces, then it goes to his legal heirs. He can make property, which it goes to the legal heir. 15-20 मिनट है ना अभी?
नहीं,
नहीं?
नहीं, speaker.
हाँ, अच्छा आ गए।
वो आ गए तो 5-7 मिनट तक हो गए ना।
तो मैं क्या करता हूँ, ये जो सजेस्टेबल पॉइंट है ना,
Please,
वो तो आप पढ़ लेंगे, इट इज वेरी क्लियर।
and no questions.
Because he's already come.
Where
10
will
मिनट
can be
है, 10 मिनट, 5 बजे close करेंगे।
where will can be contested. Even I was knowing कि 2 घंटा मेरे से इनफ नहीं होगा।
सर दूसरा सेशन रखेंगे नेक्स्ट सेशन।
नहीं, वो ये चलेगा। Where it can be contested, where it is not in terms of the section 59, 60 or 63. 59 says if it is intoxication something, 61 is saying fraud, 63 says that testator signature and witness signature. If these are not there, whether it is influenced by someone else or suspicious circumstances, then will can be contested. Probate, I think we have discussed everything. Caveat also, I think we have discussed.
Yes.
If you object, then we have to file objection to the court, which is known as a caveat, that I object, and then the matter goes on to go on the plea. वो ये भी डिस्कस होगा कि we can put a clause if somebody dispute, he will not get the property. But it works in double edge. If genuine person is filing, then he may suffer. Now, successor. Now, in case of a intestate successor, there is no will, the property will go as per the Hindu Succession Act. In case of Hindu male, first is class 1, then second is class 2. In case of class 1, Hindu married male, son, daughter, wife, and mother, they will get an equal share. This is, we are talking about the all personal property. I am not considering the section 6 of the joint family property. If son is not there, then whatever is share is there, son share. Suppose there are 4 people, then son share will come 1/4. If son is not there, then his widow or son or daughter, they will get. If they are not there, then uske niche aayega. Daughter, same. Now, Hindu unmarried male goes to the mother. That is
Yeah, obviously, because son, daughter, and spouse is not there. Only person.
father.
No, but father is not anyone is other than.
Unmarried male, father हो सकता है ना?
I'm saying in birth also it is.
हाँ. So Hindu
In birth
unmarried
also it is
male
not
goes to the mother. Now, all this will take simultaneously. Suppose class 1 का ऊपर का जो है कोई नहीं है, then it goes to the class 2. They will go by one. अगर father है तो father जाएगा, father नहीं है तो second नहीं है तो third. Like that it will keep on going.
Father
Father है ना?
Second.
Second. Yeah. Class 2. अगर class 1 में कोई नहीं है तभी ये आएगा. And class 2 में भी ये order में जाएगा. Now, Hindu female. That is also your son, daughter, and husband. Son, husband, and daughter. Then like that. But in case of a Hindu female, class 2 also given. It will go like that. Important point is there. In case of Hindu female, when inherited property from parents, there is a different rule. It won't go to the husband. It goes to the father's share, her father's share. If female has inherited property from her parents, Then if she dies, it will go to her father's side because it has come there. But their issue is there. Mother, not there. Father's here, not mother's here. He might have inherited from mother also. Then also it goes to the father's here. That is just here. Now nomination is what we have discussed. It is compulsory. Nominees are the trustees, as we have already discussed. So mutual fund no issue. Now general access fund to general room. Shares are trustees. Insurance. Exception let us discuss. One is insurance. Insurance में 2015 में amendment आ गया है कि nominees become the beneficial owner. So we have to take enough care. But if nominees are other than the family members, then it goes the normal course. But family members में किसी एक को भी nominee क्या he become absolute owner compared to the other family members. This is very disturbing because while taking the policy, we do not know. We just nominate someone. अच्छा, insurance policy में क्या होता है? Nominee भी किया, कुछ भी किया है. Creditors have a right from the proceeds. उसका way out क्या? Take the policy in Married Women's Property Act. You can't change the nominee, and nominee can be wife and children. It's over. No one claim. Even the maturity claim goes to the wife. Here in Provident Fund, it is very difficult. In this all case, they have defined the family and they don't give option to nominate other than the family members. We have to appoint and they become the legal owners. That is the problem. Now the share, as we discussed. Till 20, it was all decided. Final judgment was division bench. In SD case, nominee are the trustees, even in case of shares. But in case of Aruna Oswal case, 15. In paragraph 15 in 2020, they observed, Supreme Court, it is prima facie apparent that vesting is absolute and the provision supersede by virtue of non-obstinate clause any other law for the time being enforced. Prima facie shares vest in nominee and becomes absolute owner of the security or the strength of the nomination. ये एक पैरा में ऐसा लिखा है, जजमेंट में नहीं है. जजमेंट में लिखा है कि वो सिविल कोर्ट का केस पेंडिंग है, वो डिसाइड करेगा. बट ये क्लियर कट करने से लीगल से वो तकलीफ हो गई, अनसेटल कर दिया है. The how the court will interpret whether it is a ratio or it is a obiter dicta. It is in my opinion, it is obiter dicta.
But it was related to Kolkata.
No, it was related to the shares. ओसवाल एग्रो का शेयर था और उसमें प्रॉब्लम क्या था? ऑपरेशन एंड मिसमैनेजमेंट का केस था. वो बोलता है ये नॉमिनी है, वो मेरे पास ही आ रहा है, तो मेरे पास 10% होता है. वो बोलता है नॉमिनी के नाम पे तो अभी नॉमिनी है. उसमें ये बाईपास रिमार्क आ गया. आई थिंक no, this is mainly for the equity shares. बाकी रेस्ट no, they are the all trustees basically. So thank you friends. I hope most of your doubts are clear.
Somebody writes in a will that my British marriage and nation as per will must be given to that person. That's why
No, that's the point. No,
that is not allowed.
it is allowed, but the point is that it was in insurance. It is difficult. PF and everything is difficult. शेयर्स का सेटल हो गया अभी, तो अभी अनसेटल कर दिया कि नॉमिनी बिकम द ओनर.
To ensure that you match the nominee and the beneficiary, that is the best position. Try to do that.
या
Try to do that.
Yes,
As far as possible.
तो क्या करो, जिसको देना है उसको ही नॉमिनी करो.
It's better.
Always better.
But so many places they ask you non.
Which is not a owner as of today. Suppose you're going to be a owner of the property after 6-8 months.
Sorry,
Is it possible for a person to include in his will a property which is not a owner as of today?
which is void.
No, you can't.
You're not
If you're not-
You can't. You can only dispose of your property. If somebody property you return it, it becomes the void. It won't take effect.
acquire करने वाले
नहीं, अपन वो रेसिडुअल में आ जाता है. रेसिडुअल
सकते हैं.
वो रेसिडुअल में वो रेसिडुअल में आ जाएगा. और उसके बाद भी अगर कुछ ज्यादा आ गया रेसिडुअल में, उसको भी आपको तो विल नया बना दो, समझो. उसके बाद आपको वो then residual will go. Residual clause will be there. वो सब क्लोज मैंने डिस्कस नहीं किया ना, अभी टाइम के हिसाब से स्किप किया.
समझो after the date of the will,
अलग से भी पढ़ना.
I think we are
running out of time.
no, we have already gone. I think we keep one more session for them because succession
Only question answer हो जाएगा.
only question answer, and I will cover the other things. I will cover taxation also and other Mohammedan, Christian, Parsis, even nomination that share point also we will discuss in that.
Certificate cost करता है उसका भी
कोर्ट फी तो लगेगा ही, कोर्ट का कोई भी प्रोसीजर में. जब प्रोबेट में लगता है तो
in case of will, if there is no will, then succession certificate.
then also.
And one owner is
Already discussed.
and you go under.
It's already discussed.
Your share will be executed. That's exactly his case. That's exactly his case. What he said. There were 3 owners in his case. The one owner expired. He made a will. He is given to the second owner. He obtained the probate. The society will delete his name. It becomes 2/3 and 1/3.
Let us take balance questions 1 to 1.
Thank you.
Yeah, please.
Thank you, sir.
So thank you for all patience learning.
I think it has been a very interactive and wonderful session. To propose a formal vote of thanks, I would request Nidhi ji.
It is said, death is not the end. There remains the litigation over the estate. So, thank you, sir. It was a wonderful session. Thank you, participants, also for having such an interactive session. Everyone could get knowledge out of it, I guess. And it was a profound learning for me as well. I knew so many terms from it. So we have to keep a second lecture, obviously. So I propose a hearty vote of thanks for sir.
Thank you. So our second speaker is also here. So we'll just take a 2 minutes short break while I set up the computer and then we start the second session.
लेकिन everybody has to be here.
आपने लड़की को अटका के रखा है.